That doesn't work. I know you guys have seen a lot of people on YouTube videos saying, I don't answer questions and these things, but those people are not constitutional law scholars. And so I want to share with you something that you absolutely have got to know. The reason why I made the Trifold and the 5A cop card, it's called the 5A cop card. Why is that? Why do you think the main square of the 3 panels, I invoke my Fifth Amendment right to remain silent? It says Fifth Amendment on it, and then you state it. Fifth Amendment, I invoke the right to remain silent. You have to say those exact words. And why is that? Why do you have to say the words? Well, it's the Supreme Court. It's the same thing. In the 2013 case of Salinas versus Texas, sorry, let me you guys see this. Salinas versus Texas. You have to say out loud, I invoke my Fifth Amendment right to remain silent. In 1992, Houston police officers found 2 murder victims. The investigation led to Gennaro Salinas. Salinas agreed to accompany the officers to the police station where he was questioned for about 1 hour. Salinas was not under arrest at the time and had not been read his Miranda rights. Salinas answered every question until an officer asked him whether the shotgun shells found at the scene of the crime would match the gun found in Salinas' home. According to the officers, Salinas remained silent and demonstrated signs of deception. A ballistic analysis later matched Salinas' gun with the casings at the scene. Police also found a witness who said Salinas admitted to killing 2 of the victims. In 1993, Salinas was charged with murder but could not be located. 15 years later, Salinas was finally captured. The trial ended in a mistrial. At the second trial, the prosecution attempted to introduce evidence of Salinas' silence about the gun casings. Salinas objected, arguing that he could invoke his Fifth Amendment right, protection against self-incrimination, whether he was in custody or not. The trial court admitted the evidence, and Salinas was found guilty and sentenced to 20 years in prison and a $5,000 fine. A $5,000 fine, there's the government just trying to get money out of anybody, even murderers. The 14th Court of Appeals, Harris County, Texas, affirmed, noting that the courts that have addressed this issues are divided. The Court of Criminal Appellates in Texas affirmed. So here's the constitutional question. Anytime it goes to the Supreme Court, who works against us, who is the enemy of the people, 98% of the time, they are the enemy of you and I. Right now, the Supreme Court's upholding our Second Amendment right because Clarence Thomas is bought and paid for by a billionaire gun lobbyist who loves guns. So Clarence Thomas is leading with Alito, and so the other 4 conservatives. And so they're doing the only thing they've ever done good, this court, which is fight for our Second Amendment right. So when it goes to the Supreme Court, though, there's always a constitutional question. Remember what it said here a moment ago. I'm going to back up just a little bit. It said here, noting that the courts have addressed this issue are divided. The courts that have addressed this issue are divided. So the court in Florida, the court in Tennessee, the court in Texas, the court in New York, they're divided on whether or not the Fifth Amendment, whether you have to state it or not. And the Criminal Court of Appeals of Texas affirmed the holding. So the constitutional question now that the Supreme Court is going to take up is going to say, does the Fifth Amendment self-incrimination clause protect a defendant's refusal to answer questions asked by cops before he has been arrested or read his Miranda rights? And of course, if you go by ideology, the same conservatives who I just said are upholding our Second Amendment right, they constantly side on the side of the cops. And this is a 5-4 decision, meaning that it's completely done on ideological lines. The question was, does the Fifth Amendment does it protect a defendant for refusal to answer questions? No, it does not. Samuel Alito, who's still on the court, announced the judgment for a divided court. Alito, joined by Roberts and Kennedy, concluded that the Fifth Amendment privilege against self-incrimination does not extend to defendants who simply decide to remain mute during questioning. You have to say the words. I don't answer questions is not saying I invoke my Fifth Amendment right. Long-standing judicial precedence has held that a witness who desires protection against self-incrimination must explicitly claim that protection. Did you read that? This is from the holding of Salinas versus Texas. Long-standing judicial precedence has held that any witness who desires protection against self-incrimination must explicitly claim that protection. What protection are they talking about? They're talking about your Fifth Amendment right to remain silent. You have to say it. Fifth Amendment, I invoke the right to remain silent. You have to say it. And in today's world, if it's not on camera, it didn't happen. You're reading the holding. I'm just giving you the knowledge. I'm showing you where to look on the 5A cop card, on both cards, driver or non-driver. What does it start off with saying? Number one, I see a cop. I start filming. I invoke my First Amendment right. Number two, a cop approaches and says any words at all. While filming, I invoke my Fifth Amendment right to remain silent. Fifth Amendment is unequivocal. Cop loses qualified immunity for questioning you further. I didn't create this. I created the card. I created the Trifold. I didn't create this bullshit system where we have a Fifth Amendment right to remain silent, meaning I can sit here mute, and then the corrupt, unelected monarch Supreme Court of the elitists, if they want to catch a murderer, they go, oh, no. It's a murder case, y'all. It's a murder case. We have to create a little caveat into your rights for murderers. How many of you are murderers? 99.99% of us are not murderers. They created a caveat into our Fifth Amendment right where you have to state it. I don't answer questions is not the Fifth Amendment. I stand mute is not the Fifth Amendment. Read it again, my friends. Read it again. Long-standing judicial precedent, that's not true. They made that up, has held that any witness who desires protection against self-incrimination for you not to get in trouble by the state when they're questioning you must explicitly claim that protection. This requirement ensures that the government is put on notice when a defendant intends to claim this privilege and allows the government to either argue that the testimony is not self-incriminating or offer immunity. The plurality reiterated two exceptions of this principle. One, that a criminal defendant does not need to take the stand at trial in order to explicitly claim this privilege. So you don't have to be in trial. You can be on the side of the road. And then two, that fails to claim this privilege must be excused when that failure was due to government coercion. The opinion declined to extend those exceptions to the situation in this case. Notwithstanding popular misconception, the court held that the Fifth Amendment does not establish a complete right to remain silent, but only guarantees that criminal defendants may not be forced to testify against themselves. Therefore, as long as cops do not deprive defendants of the opportunity to claim the Fifth Amendment privilege, there is no constitutional violation. In a separate opinion, Clarence Thomas wrote that Salinas' Fifth Amendment privilege would not have been applicable even if invoked because the prosecutor's testimony regarding his silence did not compel Salinas to give self-incriminating testimony. Justice Anthony Scalia joined his opinion. Justice Stephen Breyer wrote a dissent in which he argued that Salinas' silence was enough to claim the Fifth Amendment privilege and that the majority decision raised clear problems for uneducated defendants. Holy smokes, who may not know the explicit language necessary to protect their rights. Do you believe me now that you have to say the words? I made sure it was clear as a bell. On the Trifold, I said, know your rights. On the other side, as soon as you pull it down, it says, Fifth Amendment, I invoke my right to remain silent. You have to say the words. You read it yourself, right? Did everybody see it? Yeah, just so you guys know, I got an ebook that I give you guys when you purchase anything from my website. I also have a poster that I give you guys when you purchase anything. I did the math yesterday. I put a little over $6,000 into creating these cards, a little over $6,000. And what does it say right away at the top? If you're the non-driver, you start filming and you say, I invoke my First Amendment right. And then number two, cop approaches, says any words at all to you. While filming, I invoke my Fifth Amendment right to remain silent. That's on the non-driver card. On the driver card, it says, cop pulls you over while filming. You state, I invoke my First Amendment right, and then it's upheld by Turner versus Driver and my First Amendment. Number two, cop approaches, states alleged infraction, or questions you. Filming, give cop all required legal documents, and then you state, I invoke my Fifth Amendment right to remain silent. Do we understand now? Like, I'm not making up these rules. I'm not making up these rules. The Supreme Court's doing this to us. The Supreme Court is working against us and has since the very beginning. Since the very beginning. The reason why constitutional law scholar is taking so long is because I've had to do so much case study from the 18th century and the 19th century. There's so many cases the Supreme Court decided against our civil liberties, against our rights, against our children, against our labor since the very beginning. When does a cop have a right to touch you? The moment he sees you. Why does he have the right to touch you? Terry versus Ohio.